Constable Scrimjar was on a general patrol on March 14, 2018. Part of his duties include entering license plates of the various vehicles on the road into the battery of databases available in a police car. That involves entering a license plate into his onboard computer. The computer sends the query, and the various databases return information directly to the officer in the car. Constable Scrimjar was alone that day in his cruiser driving eastbound on Highway 7 at about 5:40 p.m., querying cars in this area. He saw a 2013 Honda Civic with license plate CVPX169. The query came back from the Ministry of Transportation that the Honda was registered to Michael Stewart, an address in Brampton with a date of birth. The Honda was not the only license plate he had run in that time frame. The computer query returned nothing glaring or unusual from the ministry records, so he made a right turn, turning his vehicle southbound, away from Highway 7. At that point, a CPIC query returned to the car about the Honda. The registered owner of the car, Michael Stewart, was accused of several crimes in Windsor and was on a reconnaissance. The CPIC query gave the conditions of the reconnaissance and a photograph of Michael Stewart. Mr. Stewart's reconnaissance had several conditions. He was not to be in possession of unlawful drugs or weight scales. He was permitted one cell phone, and he was not to associate with Josh Isaacs. The bail was for drug trafficking charges. Once this information came into Constable Scrimjar's computer screen, he made a U-turn and returned to Highway 7. That U-turn was made 10 seconds after he had turned off Highway 7. That permitted him to see the Honda Civic as it passed in front of eastbound. The car had two occupants, both male. He could not see the faces of the occupants, just their approximate age, which was around 18 to 30 years old. He believed both men were black with shorter hair, but not much else. It was then, 5:48 p.m. When Scrimjar's car re-entered Highway 7, it was directly behind the Honda. Constable Scrimjar activated his roof lights to stop the Honda, which he did within seconds. The sequence of the traffic stop was captured by Constable Scrimjar's in-car dashcam. The dashcam recorded the conversation, which was real help in deciding this case. Scrimjar said he stopped the car under the Highway Traffic Act to ensure that the vehicle had all its documentation. He also testified that he was aware that the vehicle was owned by an accused person and he wanted to ensure that Mr. Stewart was not breaching any of his bail conditions. Upon approaching the car, Constable Scrimjar looked in the car and could see the driver. Having seen the picture of Mr. Stewart on his own car computer, he was satisfied with his identity. The time from when Scrimjar first approached the window of the car to the time he told both men that they were under arrest was less than a minute. Both accused were then under arrest for possession of a controlled substance, namely marijuana. It was 5:51 p.m. Mr. Saunders falsely identified himself as Sean Campbell with a date of birth of January 1st, 1993. Officer Scrimjar could see that Mr. Saunders, the passenger, had a satchel on his body, which he was holding tightly. Scrimjar told him, while he was still in the car, "I need you to keep your hands where I can see them. Don't do anything stupid, alright?" Mr. Saunders then got out of his passenger seat. Scrimjar asked him to hand over the satchel, which he did. It was placed on the roof of the car. Scrimjar asked Mr. Saunders what his real name was, and he continued to say it was Sean Campbell. Constable Harrison arrived on scene and met with Officer Scrimjar, who directed him to arrest Mr. Stewart, the driver. The arrest of Mr. Stewart happened at 5:57. Scrimjar also searched the Honda incident to arrest and found cell phones, packaging bags, and digital drug scale. 4.3 grams of marijuana was seized on the passenger side of the car, wedged in the area between the seat and door. A marijuana cigarette, or spliff, was seized from Mr. Stewart. Mr. Stewart was seen on the video at 5:54 throwing something out of the driver's window onto the roadway. Constable Harrison retrieved it, and it turned out to be two plastic wrap packages containing 10.17 grams of heroin and 15.33 grams of cocaine. This relatively brief roadside interaction gives rise to a number of charter-based arguments on behalf of both Mr. Stewart and Mr. Saunders. They claim that their rights under S9 were violated because the initial traffic stop had no legal basis and was therefore arbitrary, that the ensuing arrest was therefore unlawful and the search of the vehicle and both men incidental was unreasonable because the arrest itself was unlawful, that their rights under S10 were violated because they were never informed of the reason for the stop and were not given constitutionally valid information about rights to counsel. It is another frailty in his evidence that when he was confronted in court with the fact that he never bothered to ask for documents from Mr. Stewart, Mr. Scrimjar, as one would expect, when the reason for a vehicle stop is to search for documents. He said that if the passenger had turned out to be a female, he would have asked for the vehicle and driver documents from the start. That is internally inconsistent with his other evidence, that he saw two black males in a car, as it passed before him on Highway 7. Mr. Stewart and Mr. Saunders were released of charges. The S9 breach is especially significant. There was no legal basis to stop the Honda that afternoon. His pretext stop was not grounded in the Highway Traffic Act or any other common law authority to detain for a bail compliance check. It is concerning that Scrimgeour attempted to explain the stop as justified under the HTA. This led him to give testimony which was inconsistent with what he was arguing, namely telling the parties at the scene that they were stopped for a bail compliance check, when in court he continuously mentioned that it was a habitual HTA stop. The S10B violation is less serious. Scrimgeour told them their rights to counsel but did not get it right. The S9 breach is sufficiently serious that the first prong of the S24-2 can only conclude towards exclusion of evidence of possession of drugs, trafficking, and/or distribution of drugs. The effect of the charter's protected interests are significant. Because of the unlawful stop, Mr. Saunders and Stewart were vulnerable to a visual and olfactory search by Scrimgeour, which resulted in their immediate arrest for a drug charge. The reason for the stop was for bail compliance and not HTA purposes, as he mentions in court. There was no apparent HTA violation and no interest in checking the driver of the Honda to confirm that he had the necessary documentation for the vehicle. Therefore, his arguments in court were heavily inconsistent with the conversation that was recorded at roadside. In the circumstances provided during the roadside questioning, both accused have established that their rights under S9 of the Charter were violated when the car in which they were traveling was detained arbitrarily. When pulling over a citizen roadside for a certain reason, and discovering during the stop that there is a more significant illegal activity being done, do you agree the course of action taken by the court is legally and ethically the right decision? To let the accused free even when possessing clear evidence of a crime? To what extent should the court consider crime over the reason for a roadside stop, if there is such a case?